A federal judge in Washington, D.C. has blocked President Trump's executive order that bans transgender individuals from serving in the military. Judge Ana Reyes issued the ruling, stating that the ban likely violates the Constitution's Equal Protection Clause. The ruling is a victory for transgender rights advocates and a setback for the Trump administration. The administration is likely to appeal the ruling. The ruling came after a group of active-duty transgender service members filed a lawsuit challenging the ban. The plaintiffs argued that the ban is discriminatory and harms military readiness. The judge agreed, finding that the ban is not supported by any legitimate government interest. This is not the first time that Trump has attempted to ban transgender individuals from military service. In 2017, he announced a similar ban on Twitter. That ban was also challenged in court and ultimately blocked by federal judges. The Trump administration has argued that transgender individuals are not fit to serve in the military. However, this claim has been disputed by medical experts and military leaders. The American Medical Association has stated that there is no medical reason why transgender individuals cannot serve in the military. President Trump's executive order banning transgender individuals from serving in the military was based on the premise that their presence disrupts unit cohesion and undermines military effectiveness. The administration argued that the medical costs associated with gender transition treatment are too high, and that the presence of transgender individuals in the military would negatively impact morale and readiness. The defense, representing the Trump administration, echoed these sentiments, asserting that the military should have the autonomy to establish its own policies regarding service members. They argued that the president, as commander-in-chief, has the authority to determine who is fit to serve in the armed forces, and that the ban on transgender individuals is a matter of national security. Furthermore, the defense emphasized that individuals with gender dysphoria, a condition where a person experiences discomfort or distress due to a mismatch between their biological sex and gender identity, do not meet the military's rigorous physical and mental standards. They maintain that the ban is not discriminatory, but rather a necessary measure to maintain the combat effectiveness and operational readiness of the armed forces. The defense also pointed to the potential logistical challenges of integrating transgender individuals into the military, such as providing separate housing and bathroom facilities, as well as the complexities of addressing issues related to deployments and medical care. They argued that these challenges would place an undue burden on the military and detract from its primary mission of national defense. The plaintiffs, a group of transgender service members, argued that the ban is discriminatory and violates their constitutional rights. They asserted that they are capable of serving their country with honor and distinction, just like any other service member. They emphasized that their gender identity does not affect their ability to perform their duties effectively. The plaintiffs presented evidence that transgender individuals have been serving in the military for years without any negative impact on unit cohesion or military readiness. They cited studies showing that transgender service members are just as capable as their non-transgender peers, and that their presence in the military does not harm morale. They also argued that the ban is based on prejudice and misinformation, rather than on any legitimate military concerns. They pointed out that the medical costs associated with gender transition treatment are minimal, and that the military already provides a wide range of medical care to its service members. The plaintiffs emphasized that the ban harms military readiness by forcing talented and dedicated individuals out of service. They argued that the ban sends a message that transgender individuals are not welcome in the military, which could discourage qualified individuals from enlisting. The government's primary argument for the ban centered on the principle of military discretion. They maintained that military leaders should have broad authority to make decisions about who is fit to serve, free from judicial interference. They argued that judges lack the expertise to second-guess military judgments regarding personnel policies. The government also contended that the ban is necessary to uphold military standards. They argued that individuals with gender dysphoria do not meet the physical and mental requirements of military service, citing concerns about the potential impact on combat effectiveness and unit cohesion. Reactions to the ruling were swift and divided. Stephen Miller, a senior advisor to President Trump, criticized the decision as judicial overreach. arguing that the court had overstepped its bounds by interfering in military affairs. He vowed to appeal the ruling and defend the president's authority as commander-in-chief. Plaintiffs' attorneys, on the other hand, hailed the ruling as a victory for equality and justice. They praised the judge for recognizing the ban's discriminatory nature and for upholding the constitutional rights of transgender service members. The ruling was met with celebration by LGBTQ+ advocacy groups and their allies, who viewed it as a significant step forward in the fight for transgender rights. The ruling's broader impact on the transgender community and military policy remains to be seen. It is likely to face further legal challenges as the Trump administration seeks to overturn it. However, for now, it stands as a powerful affirmation of the rights of transgender individuals to serve their country without discrimination.